Hello, everyone. Welcome to EBC Learning. I'm Dr. Rachel Dua. I'm a senior consultant with EBC Learning. At EBC, I'm responsible for managing the delivery of all our academic programs. Today is the first class of our 3 days complimentary preview course on intellectual property. We will be discussing commercialization patents in this preview course. You will be given a practitioner's perspective on protecting innovations, what to look for in licensing IP, and the best practicing in drafting IP agreements. We will have some interesting discussions on whether innovators must consider patents or trade secrets to protect his ideas. Now, this course will be conducted by Mr. Ashok Venkatesh. He is a dispute resolution counsel, has represented clients in the food, healthcare, pharmaceuticals, aerospace, defense and technology, banking, and financial services, to name a few. His work in the field of intellectual property rights involves not only advising and assisting clients in protecting and commercially exploiting intangible assets, but also in representing clients in various IP litigations involving trademarks, copyrights, and trade secrets. And let me tell you that Mr. Ashok is also one of our faculties for upskill diploma course as well. Welcome, Ashok, to EBC Learning. Also joining here with me is my colleague, Dr. Pratima Narayan. She is an advocate, mediator, and co-founder of Technology Consulting LLP. She is also an editor, consultant, and faculty at EBC Learning. Also, she's the one who has conceptualized this course on IPR. She is very much instrumental in curating this comprehensive e-course. In another 5 minutes, we will understand from her the brief overview of the content, structure, and assignments. Now, once you register with us, you can view various courses on our portal, which are fully available, or you might have some limited access, which you can definitely upgrade with us. There are courses on IPRs available on IPRs as well. Just let us know in case if you want to upgrade as well on those courses. But before that, I would just like you take you through the learning management system. So just give me a moment. I'll just share my screen now. Thank you. I hope you all can view my screen. So here, once you click on the Commercializing Patents Diploma and Advanced IPR Complimentary Preview course, you will land up on this particular page. And if you see on your left-hand side, so these are the contents which are given as the welcome tab, in which there is a brief description of our full program is given here. And then the teaching team, which I have already introduced to you all. We have Dr. Pratima Narayan as a program leader, and also our lead instructor, Mr. Ashok G. Venkatesh. So you can go through their profiles here. And then we have the student introductions here. Student introductions is basically you can introduce yourself and you can let your fellow learners know a little bit about you. It is also kind of a discussion box in which you can post your questions and queries in case you have regarding the course. So we'll sort it out as a faculty will help, and they would answer all your queries here. And then we have the key dates and class details. Now, in the key dates and the class details, as you know, till 20th of March, we need to complete all the pre-class readings and watching the course, video lectures, etc. The first class, that is today, that is about to begin, and we will be discussing the introduction of patent licensing and commercialization, which is the most practical way. And then on 21st of March, you would be spending some time over the course, anticipating yourself for the next session. And the next session you can see is on 22nd of March, and the details are very well given in the key dates here. And now, if you look again on your left-hand side, so these are the before the class, what needs to be done. So these are the videos that needs to be watched before the class. For example, in the introduction, you would have a videos on evolution of IPR, rationale behind IPR. So these are the pre-reads that needs to be done before the class. So it's structured properly, so you can just go and watch the videos. You can click on the topics from the left hand side and you can watch the videos here. And so these are the forms of IPR, conceptual analysis, introduction to patent law, patentable subject matter, patent registration, and also there are some readings that needs to be done before the class. So after that, there is a live class, which is today. You can just, I'm sure you must have joined it from here. So here there is an option to join the class, and then there is a post-class assignment that will be discussed in the class, and you can upload it here. So this is the post-class assignment. You can upload your assignment in this way, like you can upload it, you can use a Word, and then you can upload your assignment. You can read it thoroughly. It will be discussed in the class. So classes are more of an interactive and based on discussion. So most of the work is done in the pre-reads here. And again, there is a pre-class 2. Before the pre-class 2, there are things that needs to be done. That is, again, some watching the videos and doing the pre-reads through the compulsory readings here. This is our full program on upskill diploma in intellectual property law, where you have a full overview of what exactly is there in the intellectual property. So this upskill diploma in advanced intellectual property program is designed by professionals to bring comprehensive understanding of every stage involved in the life cycle of intellectual property. This course is useful for aspirants who wish to further specialize in intellectual property and engage practically. So we will be discussing more on a conceptual and case-based learning that will help you develop a deeper insight into the subject of IPR. More from Dr. Pratima. Dr. Pratima, I'll just hand it over to you to just give us a more overview of the content, its structure and assignments, and how do we go ahead about it. Thank you. Over to you, Dr. Pratima. Thanks.
Thank you, Dr. Archit, and welcome everyone to this preview course on commercialization of patents. The idea of introducing a preview course before we get to the larger diploma course of a year-long program is to sort of give you a prelude into how the courses are, the entire program is structured, and what is it that a participant will have to look into before they come into the class sessions, while the class sessions go on, and what are the assignment structures. So this is just a sort of a prelude, that's why we call it a preview course, where you get to understand how the sessions are designed, how the course is designed, and how the program is structured. I'll just take a moment to quickly run you through the upskill diploma in advanced IPR program. Allow me to share the screen. Okay, I hope you're able to see the portal. So here's the link to the upskill diploma in advanced intellectual property rights. The program is brought to you by EBC Learning in association with CII, one of the largest industry bodies in the country. Now, let me just run you through a quick overview of how this program is structured. You have the entire syllabus that's provided on the portal. So you can get to see the short structure, which I'll be explaining to you very shortly about each of these programs. I will just come back here to this program, where you see that there are about 7 modules that you will be studying. So I'll just give you a brief introduction about each of these modules and what are the highlights of these and what is the advanced learning that you take away out of these programs. As you would know, the life cycle of an intellectual property would depend on 4 very broad stages. One is to identify the intellectual property itself, to register the intellectual property, not just registering the intellectual property, but also to manage the intellectual property at its various stages, including renewals, commercializing, etc., which we are going to have a brief understanding about commercializing intellectual property in today's session. And finally, also protecting your intellectual property against infringement during the course of its term, the term of the intellectual property. So for a better understanding the flow of the subject, this advanced course, as you would see, is classified into 7 modules. So what are these advanced learning you would have out of the course that will help you step up from just being a beginner in intellectual property rights to being sort of industry ready and professional to handle these registration processes or drafting or managing the intellectual property rights? So as you would see, the course begins with a brief introduction to the intellectual property itself, which is of course a conceptual learning of the IPR that would enable you to identify how you build a comprehensive intellectual property around innovations. So the very idea is to help you identify the intellectual property itself. So this would help you to determine the distinct characteristics of each forms of the intellectual property. And this would also bring you some kind of a practitioner's perspective as far as the criteria for protection is concerned, where and how applications fail at the intellectual property offices. What should IP professionals and lawyers consider while they advise their clients before even considering an intellectual property registration? So these are some of the things that you would be acquainted with in the first module. The second module, of course, that is subject matter and criteria for protection. The third module onwards, we will be introducing you through some workshops, which would include workshops like prior art search, which would help you understand what is prior art search, how you actually do a prior art search of probably a given innovation or a trademark or whatsoever. To familiarize with filings, timelines, and each stage of the IP filing, it would also give you a perspective of how the office actions are come up during an IP filing and how responses are provided to these office actions. So these are the practical knowledge that you would acquaint yourself through the third module, that is the IP registration. And then coming to the more interesting part, that is intellectual property contract drafting. That is, we start to identify the commercial aspects of the intellectual property. So here you would have hands-on experience in drafting intellectual property contracts, something like technology transfer agreements or NDAs, and a very interesting part of today's discussion also being whether an innovation should be considered for a patent registration or should be considered as a trade secret and just keep it as is, or maybe in terms of NDA, filing NDAs or whatsoever. So these are some of the things that you would have as hands-on experience in drafting some of the important IP-related contracts. The next module would be on intellectual property management, where, as you would know, that leveraging intellectual property to its fullest potential would definitely involve a well-structured management and a well-structured management throughout the life cycle. Here you would be provided with some really interesting insights into managing how companies manage very large IP portfolios. For instance, they might require an excellent docketing system. So how is the docketing system when it comes to intellectual property management or IP management, IP due diligence? So these are some of the things that we would be providing you insights into the intellectual property management. So, or it could also be in terms of digital rights management, which is one of the most important aspects that is in the present digital world. It could be relating to intellectual property valuation. So these are the areas that we focus on in terms of intellectual property management, infringement of intellectual property rights, where you would learn about where and how to file an intellectual property infringement suit, drafting intellectual property litigations, preparing yourselves for a litigation, challenges as far as enforcing intellectual property disputes are concerned, especially cross-border issues, etc. So these are some things you would be acquainted with in the module on infringement of intellectual property. And there's another module which is kept open to sector-specific intellectual property rights. So there are many contemporary issues that have come up in terms of implications of IPR on what we call as the next-gen AI technology, or contemporary issues in IPR in terms of NFTs or domain name disputes, public health, pharma-related issues. So these are some of the sector-specific aspects that we will be considering for the purpose of the last module, that is the sector-specific IPR. So here are also a few highlights that you would take away. I will also leave it to you to just run through this platform, through this particular link to see the highlights. And it would also provide you details of how should one approach the program in terms of what are the key elements that you would have to consider in terms of preparing for a classroom session, just like the way you're going to experience through these 3 days of sessions, where you're going to have some pre-reads, you're going to come prepare yourselves to these sessions, and then you're going to engage in a lot of conversation, a lot of discussion, interaction during the session, and going to take home some assignments to just work around, ponder over what you had learned during the session. There is also, you would find links to the ebooks that you would have access to from the EBC reader, all well-authored books that you would find. You will have access to all of these. And of course, the instructors, where you would have a stellar of IP professionals, faculties, litigating lawyers, prosecution lawyers. They're coming here to share their expertise with you. So I would request you to just go through this platform, go through the page to get to know more about your instructors. And so this is just a brief introduction about the upcoming course on advanced IPR program. And without much ado, I'll hand it over to Mr. Ashok, Advocate Ashok, who will be taking over on the technical section of commercialization of patents. So over to you, Ashok. In the meantime, if anyone have questions regarding the course, the program, you could put up your questions. You could either come on audio or post your questions on chat. We'd be happy to clarify your questions. I will also be sharing the link with you on the advanced program.
All right. Okay, so before we kind of proceed to start the discussion on how do we manage innovation on a day-to-day basis, just a couple of housekeeping rules. I would request all of you to keep your video on if it's not too much of a trouble. It's always good to see the audience to make sure that the session is more interactive and less of a monologue. And two, if there are any queries or doubts, you can probably just use the raising hand option, and I will make sure that I get to you. Now, the idea of this conversation is to really discuss scenarios. It's to discuss the day-to-day challenges and problem statements that we tackle. The idea being that you get an insight into how the law actually translates to effective, risk management, effective business management on a regular basis. Okay, that said, let's quickly. So, what will we cover today? There are two different scenarios in which IPR can essentially arise, right? Now, you could be dealing with a very small business or even an individual. And now, in that scenario, IP management becomes a little bit of a less tricky exercise. The reason being that I am the inventor, I am the whole and soul of the business. I get to decide how and when and how effectively and how much money I spend in managing my IP. But today we are not dealing with individual inventors anymore. Today the scenario has changed. You have businesses of all scale, of all sizes. You have businesses with 10 employees, 100 employees, thousands of employees, if not lakhs and millions. So in a world of this nature, the fundamental requirement of most businesses is to prevent the leakage of ideas. And this is a lot trickier than it sounds. And I'll come to what the challenges are and why that is as important as it is. The next question. I know the discussion is around patents, but one should never take it for granted that patenting is the way to go if there is even the smallest of chance of getting a patent registration. The reason I say this, today you would not see a KFC or a Coca-Cola grow to the size that they're growing had they decided to patent or publicly file what they consider to be their most valuable IP. right? And that really does say a lot about choosing the right form of IP. It can be a very, very tricky subject. So that comes to the next point. How do you really choose the best form of IP protection? And always remember, this is a lawyer's job. Of course, you will work very closely with businesses. You will work very closely with the technical team, the business team. All that might happen, but at the end of the day, the buck stops with the legal counsel. What he or she recommends will essentially determine whether or not the best form of IP protection is actually achieved, right? So, with that said, now we jump into the first leg of the session, which is the context. So, the landscape for IP protection has actually changed quite a bit even since the time I graduated. 2011 to 2023, the world is almost unrecognizable. More so from the fact that I think if we were probably seeing the advent of the information age in 2011, in 2023 we are neck deep in it. Now that creates a certain unique challenges and opportunities. So take, for example, a business like Twitter. Now, one would argue that if I'm a social media company and the primary source of revenue is advertisement, then the most important form of intangible asset in my hands is the data pertaining to my users. But raw data, absence any kind of value addition built into it, seldom qualifies as IP. Right? Not to mention that raw data is also now effectively and very strictly regulated by data privacy regulations. And the line between raw data or data themselves and IP emerging out of that data is not always very clear. And how do we make that distinction can sometimes decide whether the IP strategy is effective or it is not effective. The other challenge, of course, is artificial intelligence and automation. And I think this is one of the most misunderstood concepts. I think the moment we talk about artificial intelligence, I think we almost have a very Star Trek kind of an image in our mind where an AI is now evolving. It's able to produce its own music. It's able to theorize its own algorithms. It's able to generate software code and so on and so forth. Yes, artificial intelligence is making a lot of progress in terms of what it can and cannot do. ChatGPT being a great example. But that being said, we also have to understand that as of today, legal regulation does not confer the status of an artificial person on artificial intelligence for the reason that artificial intelligence still lacks agency. It's automation versus actual cognizant sentient being. So that being said, the lines between what is created by human beings and what is created by machines is increasingly becoming blurred because of the extent of headway technology has made into automation, right? And this also means that identifying or tracing the origin or the authorship of IP is no longer as simple as it was. If 10 people have contributed to a machine learning algorithm or an artificial intelligence platform, and the artificial intelligence platform in turn is able to replicate certain code or generate further algorithms or to optimize certain operations of the software itself, how do you really trace who the original author of the entire idea is? And this, I think, is also an area where legal regulations is trying to catch up. But obviously, like with everything else, technology is moving at a faster pace. Now, the third interesting problem, I think, which is a very post-COVID problem that we have seen, is moonlighting. Now, if anybody is familiar with the idea of moonlighting, it's essentially people rendering services to multiple organizations or multiple employees at the same time, either on a basis of employment or on the basis of a contracting engagement. Now, what is the challenge here? The challenge here is, I mean, I can give you a very dystopian image, but think of a scenario where a cartoon of a person is sitting in front of the computer, and there is a straw going out of his head into the larger organization. And every idea that she is generating is automatically being sucked into the company, right? Now, that's the effect of a contract of service. which essentially means that the person who's generating the idea does so for the benefit and on behalf of and in trust for the benefit of the employer. Now, if there are two employers, whether with the knowledge and consent of the other person or not, who owns that IP can become very, very tricky and challenging. And the best example that you can think of is the self-driving technology, which became a matter of heated debate and litigation between Google and Uber, because certain people involved in the self-driving technology platform of Uber ended up joining to Google. And the result is, not only are there violations of anti-competitive covenant, but there's also a challenge of identifying which IP stays with Uber and which actually goes on to Google, right? This brings us to the next problem. There's also a sea change and shift in the generation that we are dealing with. Compared to the generation of the yesteryears, I think the generation of millennials and beyond, the way they see employment, the way they see work ethics, work culture, I think there is a lot of changes. And we can see that, for example, I think 15, 20 years back, a person who was probably putting in 10 hours of 20 hours of work every day or 15 hours of work every day was probably being applauded for being a hard worker. And today, Harvard Business Review carries an article which says that if a person is overworking, it's actually a subtle form of putting pressure on all the others to burn themselves out. And it's almost being looked down upon as a very inefficient way of working. Now, in this context, things like moonlighting can become more prevalent. It can seem perfectly normal. It can seem like the new normal. Maybe it is, maybe it isn't. The ethics of it is not in debate. But what it does is it does create challenges for people who are actually putting together the legal risk management program around intangible assets. And this can be particularly difficult because the demands of today's generations are very different from the demands of the previous generation. That also means that contracts cannot be what they were before. So this is the context that we are dealing with, right? Any questions so far? Anybody who wants to offer a quick comment before we start the next leg of the conversation?
Ashok, there's one question in the chat box. If you would like to take it now, if you would want to consider,
Sure.
Why Indian government, Apurva has a question, why Indian government is not criminalizing patent infringement?
Why Indian government is not in? So that's a great question, actually. So the reason I think that Indian government has been consistently shying away from criminalizing patent infringement is that the developing world perspective around patent law is very different from the developed world's perspective on patent law. We have to remember that international trade and economic law was essentially primarily defined by the interests and the needs of the West, Europe and the US and so on and so forth. Now, obviously, when it comes to things like healthcare and pharma and critical areas like, say, food production, healthcare, for example, the American and the European perspectives were not in alignment with the way the developing world was seeing it. And the best example is actually the Novartis judgment on Gleevec, if I'm not mistaken, where on the grounds of bioavailability being enhanced, the patent around Gleevec was sought to be renewed for a period of 20 years, not through the channels of renewal, but through the channels of a separate application, if I'm not mistaken. Now, during that process, while the question of whether to grant the patent or not was being determined, the Indian government actually received letters from several countries in Africa, and they practically pleaded the country not to grant a patent in favor of Novartis for the reason that generic versions of the same drug had significant healthcare impact in Africa. Now, Indian attitude and approach thus traditionally has been very skeptical about IP protection. And considering the very nominal sum that we spend on universal healthcare, I think we have found a very convenient workaround to actually spending more on universal healthcare by weakening or I wouldn't say weakening, but recalibrating our IP laws to make it easier to say slave off IP. So I think that's probably the thinking of the Indian government. And I mean, again, like everything else, the ethics of it can be debated, but the law is what it is. Does that answer your question? I hope. Okay. I will presume that I've answered your question. All right. Okay. Now, coming to the role of the legal counsel, obviously, with all the challenges that we discussed in the previous slide, the role of a legal counsel in terms of managing and protecting innovation has also vastly changed. Now, previously, the attitude or the predominant culture was that the lawyers will wait on the side. The scientists and the engineers and whoever else is involved in actual IP creation will actually then do their work. And once it has kind of reached some shape and structure, they in turn come and deposit the idea with the lawyers and tell them to get the best possible IP protection available. Now, this worked well, but obviously the changing needs of the times has also made life a little more complicated for everyone. So let me give you an example. Let's assume that there is an application or an AI and machine learning based algorithm that is able to process a lot of individual villagers' data to probably generate insights on, say, healthcare patterns among villages, right? Now, this will involve collecting data from each household and each individual, and then drawing the big picture from that crunching of individual data. Now, on paper, this is simple enough, right? So, for example, we could possibly identify iodine deficiencies in an entire village by monitoring the thyroid-related problems there. But the difficulty now is that that kind of appetite for individual personalized data cannot be permitted or given a free go because data privacy regulations are coming in. And Puttaswamy versus Union of India has obviously made that process a little more stringent. So it'll be the lawyer's job to come in at the very time the application is being discussed to inform the technical team that, look, your appetite for individual data will have to be tempered down. Rather, focus on the numerics of the data. How many villages in a particular district actually had thyroid-related problems, as opposed to getting individual data, and draw your patterns for village level or district level as opposed to individual level patterns. So the end output of the application will no longer say that a so-and-so person has thyroid problems because of iodine deficiency. Rather, you are now telling the output will be that, look, in this district, out of the entire population, 30% have thyroid problems attributable to iodine-related deficiencies. So drawing a generic conclusion could be more permissible from a data privacy point of view versus drawing a more individual conclusion from it. Now, this will alter the way the algorithm is being designed. This will alter the way in which data is being consumed and perceived. And as such, you as a lawyer with knowledge and insights into data privacy regulations have actually now contributed to the entire technical design of the application itself. And this is the expectation of the legal counsel of today and tomorrow. You will be expected to be part of these conversations from the very outset. You will be expected to influence the thinking and the design of these IP creation processes from the very outset. And you will no longer be in a position to remain as a bystander. Right? Now, this comes to my next point. Innovation is probably going to get increasingly influenced by legal regulations. So let's take, for example, artificial intelligence. So one of the problems that we have seen in say, the US is self-driving cars probably meeting with accidents. Right? Now, in the context of drugs and pharmaceutical products, you have a very regimented, standard setting regulation which defines what is safe, what is unsafe, how to test, how to not test. This may not be available for all sectors of innovation. Say, for example, there are places like space technology, artificial intelligence, self-driving technology. Right? Now, in these situations, setting the legal parameters for innovation becomes very important. So to give you an example, let's take an artificial intelligence tool that is able to determine what is the best combination of cancer drugs that can be administered to a person, right? Now you're essentially developing a software that is effectively substituting a big part of the work that the doctors were traditionally doing, right? Now, a question that could arise for consideration is, does this algorithm that determines the best combination of cancer medication, qualify as a drug under the Drugs and Cosmetics Act? Right? Now, at this point, I want to throw the floor open and I want you guys to come back and tell me, do you think this algorithm that's able to help in determining the cancer drug combinations, should it be treated as a drug or not? Right? Anybody wants to take a shot at that answer? Okay, if I don't see people coming forward, I'll have to probably randomly single out a person and ask them to answer. Okay, so I see there is Apurva Avasti. So would you like to probably take a shot at that question? Do you think the cancer drug determining algorithm should be treated as a drug under the Drugs and Cosmetics Act? Don't see a response. Yeah, you can also please post your answer on the chat group. You don't have to have knowledge on this, just from a common sense point of view. So let me also throw a little bit of context. If something qualifies as a drug under the Drugs and Cosmetics Act, it has to necessarily get the approvals under the Drugs and Cosmetics Act, right? Which means that nobody is going to get administered the drug without the government saying that this is fit for use, right? So it's a safeguard. So with this knowledge that the definition of drug, if something qualifies as a drug, it also means that it's subjected to governmental oversight. With this knowledge, from a common sense point of view, take a shot at the answer. Do you think the algorithm should be treated as a drug? I see one or two other names. I want to take a shot with one more person before I move on. I see one Shubham. Yeah, could you please give us your perspective on whether the algorithm should be treated as a drug or not? We don't need legally correct answers. We just need opinions. Okay, let me try and give that perspective. So I would really want this session to be interactive if possible. The only idea being that this is a vast subject and we'll have to put a method to this madness in the minds of everyone so that tomorrow you can kind of tackle the evolving challenges that will come your way. All right. So should the cancer treating algorithm be treated as a drug or not? So my two-bit is that if somebody is really mischievous, and I want to take a very commonsensical approach here, somebody is really mischievous and they kind of load all kinds of ulterior motives behind developing the algorithm, a person can be given the wrong treatment and potentially lose his or her life. Right? So the cancer treating algorithm obviously has a certain therapeutic application. It might even have certain diagnostic applications. So if it has diagnostic and therapeutic applications, which means there's an immediate impact on human health, it does make a lot of sense just from the point of view of addressing potential claims for liability that we take the safer approach, address this and as a drug falling within the Drugs and Cosmetics Act, and then tell the entire technical team that, look, you will be treated as a drug under the Drugs and Cosmetics Act. And that will also mean that you will have to get your cancer treating algorithm through the channels of clinical trials. You will have to get the approval of the Indian government for conducting the trial. You have to then identify a site, enter into a clinical trial agreement. Once the clinical trial agreement is entered into, you start the trial itself. For that, you need to get your insurance. You need to have a statistically sound clinical trial protocol. And then you run the entire algorithm through the clinical trial, where after the program is done, you know that this algorithm may or may not work, but at least it will not deliver the wrong treatment plan, right? So now look at the role of the lawyer. He has to essentially has to put one shoes in the one of his legs into the shoes of the scientist or the doctor. The other leg continues to remain in the shoes of a lawyer. And then he's supposed to then evolve the set of parameters based on which the innovation will actually function, right? So this is very, very, very critical, especially in the information age that we live in, where there's so much of emphasis on AI kind of literally taking over every aspect of human life. Being able to think laterally like this is very critical, right? Now, the third important role of the legal counsel is to obviously give legal character to business and technical ideas, right? And this can also be very, very challenging, right? Now, let's take, for example, a case of a hospital. They have developed a method to prevent falling of the patients, right? And you would be surprised to know that this is a very big problem for hospitals. Patients falling while under their watch, either when they're walking or in their steps, falling off the bed, etc., etc., etc. So a lot of hospitals put in place very stringent SOPs to ensure that the patients under their watch actually do not end up falling. Now, this is a combination of ideas of putting relevant people, installing training, then having reporting mechanisms, having patient surveillance programs put in place. So you define a very beautiful manual that kind of addresses the end-to-end of for preventing falling in the hospitals, right? Now, obviously, there's a lot of work that's gone into it. Obviously, it's got tremendous business application. Hospitals can essentially highlight the fact that they haven't had a single fall in the last 5 years. But then how do you protect it? Right? Do you choose the patenting route? Do you choose the copyright route? Do you choose trade secret as your option? Or do you kind of paint it as a combination of all of this? Do you retain it as know-how? This can be very, very challenging. Right? And it is up to the lawyer to assess the landscape of the law, understand the idea that is presented to her, and then take the final decision as to whether or not this should be patented as 1, 2, or 3, or maybe a combination of all of them. And this giving of legal character is again something that will define the essence of the attorney-client relationship of the future. The last point, of course, is the unfortunate expectation of every lawyer is to know everything all the time. And it's that one endeavor that we always keep failing at, but we never stop trying, right? And one, especially in the context of IPR, what you have to remember is the big picture, and then you start designing the smaller pictures based on the analysis of the big picture. So if today you are working with the business that's probably developed a great recipe for fried chicken, right? You also have to think in terms of 40 years ahead, when that fried chicken is going to become a franchise that's going to spread across all the countries in the world and becomes one of the highly valued brands out there, right? So you're using words like scalability, you're using words like expansion, you're using words like developing a recession-proof business method, right? And you have to essentially keep all these big pictures in mind, and then decide the smaller questions. What legal character do you give? What kind of legal parameters do you set down for innovation? How do you not remain a bystander, and how do you ingratiate yourself into the process? And believe me, these are challenges that are very difficult to address. I mean, it's very easy for me to say that don't be a bystander, but get involved. But getting that level of reciprocal, invitation from your technical and business teams can be profoundly difficult. More often than not, we are actually stepping into the picture when things are already too late, right? Because somebody did not have the good sense to tell themselves that we needed a lawyer to kind of weigh in on this, right? And to give you a simple example, one of our clients had developed a great idea, but unfortunately, the idea was not patentable. And they did not kind of think this through properly. One of them had some diploma, certifications in terms of patent writing itself. So wrote up a very nice provisional specification, very well done, filed it, and next thing you know, the idea is already in public domain, but the patent is not going to come through. So the entire business advantage was lost because of that one simple miscalculation, right? And what could have been a highly valued business ended up going nowhere in the process. So these are the kind of challenges that you'll have to tackle. And that's the reason why the space today is no longer available only for in-house lawyers or external counsels or just patent litigators or patent registration agents. The space is available for all kinds of professionals to work in a collaborative atmosphere, right? And getting this culture into the organization is going to be one of the biggest challenges that you're going to face as the legal counsel. Okay, so I pause for a second here. Any questions so far? All right, so it's a very silent crowd. Now coming to the day-to-day activities of IP identification and management. So let's start with the very basics, right? The fundamental problem that we are tackling almost on a day-to-day basis is the fruit of a poisonous tree issue, right? So what do I mean by this? Now, let me go to the largest sector in Karnataka and Bangalore, which is the information technology sector. Coding is obviously an integral part of the software industry. So you don't necessarily you can't imagine an IT sector without coding.
Right? I'm a Zoom user.
Okay. Okay. I see some interaction now. Yeah. So coding is obviously a big part of the IT sector. Now, one of the challenges that we often face is a lot of times our engineers end up, for the lack of a better word, copying code that they find online, right? And if you are in the business of, say, a B2B IT service provider, your client is, you're sitting in Bangalore as an outsourced software, service provider. You're essentially servicing a larger application which is owned by a client in the US. And in the process, your engineer has accidentally or by design, copied the code and integrated that into the deliverable to the US client, right? Now, the Indian company and the US company have an agreement which says that the Indian company will not violate third-party IPR while providing its services, right? Now, eventually, this code ends up, being discovered. So the original author of the copied code ends up suing the US customer, the Indian service provider, saying that you have essentially violated my IPR. Right? Now, the code could be small or big. The extent of copying could be a couple of lines or could be thousands of lines. That really does not make a difference when it comes to determining IP infringement. What matters is the specific code involved, its overall impact in the utility of the second tool, and how much of the original tool's essence it has managed to kind of copy. Right? So in a situation like this, that one small engineer who is probably just out of engineering college and decided that he's going to get off a little early on a Friday to go out and hang out with his family has caused the two companies a major IP litigation. Right? Now, this fruit of a poisonous tree essentially refers to an IP that is being generated, but that IP is generated using third-party IPR and probably a product of infringement. Right? Now, this is a serious problem in the IT sector, and this could be universally true for a lot of other industries also. So setting this problem right is very critical to IP identification, because I can tell you today, when we log into a Microsoft Office, the standard user agreement, even though standard user agreements are now being negotiated by business customers or enterprise customers on the ground that these issues have to be addressed, right? So even these well-established tools that have been around for probably a couple of decades now, even they are now being looked at suspiciously by customers on the ground that they could be integrating code, which is the fruit of a poisonous tree. So how do you address this? So first is you create a watertight contract that makes it very clear to your employees that they cannot and should not be doing this. Two, you need to also ensure that there is adequate level of sensitization on the good culture of IPR. So you need to help the entire employee base or the personnel of the organization understand the economic benefits, the moral benefits, the ethical values inherent in IPR, so that they're able to emotionally connect with the concept of IP protection. And number three, of course, there are very good softwares available to help you avoid this kind of pitfalls. You will have to recommend to the management that they source appropriate softwares of this nature. Though it could come at a price, it's definitely very, very valuable. So the next thing that you do, of course, is coming back to my point regarding the contract. A contract or service versus a contract for service. It's one of the oldest distinctions when it comes to agreements between employers and employees or consultants and clients. But essentially, long story short, contract or service creates a presumption that IP belongs to the employer. Contract for service need not necessarily mean that unless the clauses in the agreement clarify it. Right? Now, the title to your agreement, if you call it employment, you call it a contract of service, or you call it a contract for service, or you call it a consulting services agreement, that will not make any difference to whether or not it will be construed as a contract of service or a contract for service. Right? The test is now a lot more nuanced. You will look at things like direction and control, so on and so forth. So being able to define a watertight contract, which is highly customized for your client's needs or to your organization's needs, and is able to understand and appreciate and address all the unique contexts relevant to your business. That is the contractual needs of today and tomorrow. And in that endeavor, don't make the same mistake that the software engineer made. Do not go with templates. Sit down with your client, understand the requirement, understand what exactly are the challenges. You need to imagine what are the potential risk scenarios that you're trying to address. And then you set about the process of drafting a contract. It is not something that you do casually where you download a template, you change the names and you change the date and you just kind of sign off something. Every contracting requirement is unique in its own way, right? And being able to appreciate that is also very critical to your IP, because today, if you draft a contract of service, but essentially the clauses seem to convey the impression of a contract for service, the IP presumptions in favor of the employer may not be available. And that's a risk you cannot afford, right? Last but not the least, your contract should stipulate a duty to disclose an idea. So think of a scenario where you're dealing with a client with 10,000 employees, right? Now, each of that employee is being trained on your business, is being trained on your products and your services, is being continuously equipped to not only contribute to the process of IP, but he's also effectively innovating on his own. So in a situation like this, let's assume that either due to oversight or due to intent, he generates an idea that could be the next big disruptive trend in in the field of business, but he walks away without disclosing it to the employer and takes the idea with him, right? That can become a concern. And that is the reason why you want to be in a position where you can actually enforce a duty to disclose. So your employees or your personnel should be under a duty to disclose their ideas, especially when it is relevant to the business. And again, this is easier said than done. I'm going to take one more example and see if we can continue to, I'm going to continue my endeavor to try and make this interactive. Let's assume we live in a world where there's a tool that does reviewing of contracts automatically, right? You don't need a lawyer anymore. And I'm sure a lot of clients would be very happy knowing that. But now what happens is that the tool is able to review a 6-page contract with 1 hour of analysis and comes back with an accuracy of maybe say 60 to 70%. Okay. So it starts reviewing contracts. Now, because there's a machine learning angle to it, 6 months into this endeavor of reviewing contracts, it's able to review the same 6-page contract in half an hour with an 80% accuracy. Okay. So there's a vast improvement both in terms of speed as well as in terms of accuracy. How many of you feel that this improvement in speed and accuracy should belong to the company that generated the contract reviewing tool to begin with? Anyone? Again, we are not looking for a legally correct answer. We need opinions.
I think Apurva is asking what raw data means. Maybe you could in the chat.
Okay, raw data. So very simple. Raw data, for example, your name, right? That's raw data. The other example of raw data could be your age, right? So information in its unperturbed and unprocessed form. Now, if on the other hand, I'm able to come back with a computation that says XYZ person is actually possessing IQ of 129, has the ability to probably run a marathon of 100 meters and come first every time, that's no longer raw data, that's attributes, right? It's something that I have probably observed and have been able to capture. So raw data, I mean, it's a very simplistic example that I'm providing, but essentially information in its most unperturbed and basic form is raw data, right? Name, age, address, right? It's not rocket science. So that is raw data. So is that clear to everyone? Okay.
So Ashok, we should just go back to the same question, just reframe and make it simpler so that we can have the audience try and take the...
Sure, absolutely. So going back to my question, there is a tool that is able to review a contract, and that reviewing of the contract is being achieved with 1 hour's time with an accuracy of 50%, right? Now, as the tool is continuously put into use, 3 months or 4 months later, it is able to review the same contract at half the time with almost 80% accuracy. So this improvement in the way the contract reviewing tool is able to review a contract, do you think the company that generated it should own it?
So if it has generated the data, it should own it, no? It is
So
not a
if it
public
has
data.
generated, okay, if it's generated so essentially it's a no-brainer. The company should own the improvement in speed and accuracy, right? Okay, now let me complicate the situation a little bit. Take away the fact that the contract review is being done by a artificial intelligence tool, right? And now let's substitute that improvement being done at the hands of an actual live human lawyer, right? Now, do you want to say that the company owns the improvement over the speed and accuracy with which the human lawyer is able to review the agreement?
So then it becomes a matter of copyright, and copyright is owned by a person who has reviewed it.
Okay. So we are not talking about the reviewed contract. It's the ability to review contracts with speed and accuracy, right? And it's again a no-brainer. If I am able to review contracts faster and with much more accuracy today, that skill I carry with me wherever I go, right? My employer doesn't own it anymore. Now, this line between a human lawyer and artificial intelligence enabled tools is going to get blurred and blurred with each passing year, right? So the challenge here is that if you take away the example of a lawyer and come back to the example of the self-driving technology engineer who's probably developed a new tool to make the cars drive better, more safer, and probably faster without compromising on safety, he's obviously got a lot of these ideas running in his mind as to how to make the car faster, how to make the car safer. And fact of the matter is that he could very well not even realize that he has all these ideas. And he moves across to a competitive business because a better offer comes to him. And there the idea for the first time comes on paper and starts to translate into an actual product or service, right? This is one of the key issues that was involved in the self-driving technology litigation between Google and Uber, right? So getting a duty to disclose is one thing, but then putting it in practice, having processes in place where you're regularly having the feedback session with employees, asking them to probably fill out all the ideas that they've generated that week onto some kind of tangible form, being able to review it and see value in it, making sure that employees are incentivized beyond just the threat of a contract breach litigation to actually come back and disclose those ideas. These are the problems that have to be tackled by management and legal to be able to ensure that the improvements that are occurring, the ideas for improvements or the ideas for innovation that are occurring in the minds of the employees are not being lost to these kind of situations, right? So thereafter, you have got the disclosure, then obviously you want the employee or the personnel to be in a position to cooperate with actual registration, to sign all the contracts and all the forms necessary to register the IP, to essentially do everything necessary to ensure complete ownership of the IP remains with the employer. Right? And last but not the least, you obviously want a very clearly drafted clause that says that all IP generated belongs to the employer or belongs to the person who's commissioning the concerned personnel, right? Now, these three clauses are the basics of any contract that deals with IP identification, which then goes into the question of how the IP generated can actually benefit the company. If there is a failure of contract here, then the entire IP management pyramid that you're going to build on it is going to collapse. Right? So having that very well-drafted agreement dealing with IP identification, IP disclosure, IP-related cooperation and transfer of IP is the foundation of every IP management initiative, right? And it's very important to do that right. And this can also be subject to some very silly mistakes. So for example, if there is a confidentiality clause within the employment agreement, which talks about the duty to disclose information only to the employer, but not to third parties. 6 months later, somebody decides that, look, the earlier NDA is not, the confidentiality clause in the employment agreement is not sufficient. Let's do a proper NDA. They put together the proper NDA, but the new NDA does not contain a novation clause, which deals with what happens to the earlier confidentiality agreement. Then tomorrow it very well becomes a question which confidentiality clause actually prevails. So though it may seem very simple on paper, duty to disclose, duty to cooperate, and transfer of IP rights, in terms of practicality, this can become very tricky if you're not seeing the big picture, right? How will future contracts address this? So do you want to, for example, in the parent agreement, put a clause that says, unless there's a specific supersession or a novation clause addressing this particular IP transfer clause, this IP transfer clause will continue, right? If it does not, and let's assume the subsequent agreement actually supersedes the prior agreement, then the subsequent agreement comes into effect 8 months afterwards. What happens to the duty to disclose during the intervening period? Right? So these are challenges that can't be taken for granted. It has to be addressed in a very careful and very nuanced manner. And last but not the least, this brings me to the last point, as I call it, the notwithstanding problem. This is the issue with legal language, right? And contracts of today and tomorrow can no longer be couched in the complex legal language that we are so easily accustomed to. So using words that whose meanings are not very clear, using long sentences, not using commas and full stops in the right places, essentially generating a contract which a non-lawyer will not understand without the aid and advice of a lawyer. That contract in itself can become a pitfall. To give you an example, there was a Yale University paper which argued that these kind of standard form agreements like employment contracts with very complicated legal language, which most people without the assistance of a good counsel are not able to understand, you cannot treat it as a contract anymore. You should treat it as a product, and any harm arising out of that relationship must be treated as a product liability case, which essentially means that all the disclaimers, all the do's and don'ts in the contract is virtually useless. Right? And that school of thought actually assumed the force of law with the European Union GDPR, which said that the informed consent form for collecting personally identifiable information must be simple, easy to understand, and readily capable of being interpreted without there being a need to consult a lawyer. Right? And I have a feeling that going forward, this requirement will increasingly consume a lot of other contracts that we are accustomed to as well. Any questions so far? Okay, now coming to the question of choosing IP protection. So what are the factors that you keep in mind? Okay, so what I like to do is I sit with a client and I understand from them as to what is the target customers and which markets do they want to launch their business in, right? So for example, are we dealing with very IP friendly markets like say the United States or say the UK? Or are we dealing with markets which are not very IP friendly, which could potentially be, for example, China, right? And then basis that, you have to then determine what is the best form of IP protection that you want to go with. So that's one of the factors that you consider. Which markets will your client function in? And how do we then ensure what is the best form of IP protection across all those markets? And sometimes it may be a combination. You may want to protect it as a patent in some areas, as copyright in the others. It's very difficult to determine that question unless we know what the subject matter is. So for example, the US PTO may be a little more liberal with business method patents. The Indian IPO may not be that liberal in terms of granting business method patents. So this is a determination that you have to make based on what are the priority markets for your client. The next thing you look at is, of course, patentability. If, for example, the invention is either on the face of it non-patentable, or the patentability is suspect, you may not get patent registration. Your instinct might tell you, hey, let's go for copyright as the next best form of protection. But copyright again means a public disclosure. So public disclosure could compromise the USP inherent in your product, right? So in a situation like that, you may probably want to look at trade secret or confidential information as a better form of IP protection. But how strong are the prospects of getting patent registration will then determine whether or not you go with patent or not, right? So life cycle of the business, there are some businesses that have really withstood the test of time. And they could be for two reasons. One is because they have continuously innovated, and therefore the earlier ideas are no longer relevant, but newer and better ideas are coming out, keeping the business afloat. Or there could be scenarios where, because something has been kept as a closely guarded trade secret, the business has survived for maybe 5 or 6 generations, right? So if you'll see a lot of restaurants in the country which probably have started in 1908 or 1878 or 1900, they have probably been around for as long only because they've been able to keep the recipes completely confidential, right? And that has its own pros and cons, which we'll analyze later. But essentially, life cycle of the business, how long do you want to keep the business alive, and what's the sustainability you're looking to achieve, will determine what is the form of IP protection you want to choose. And bear in mind that there could be times when, for example, patents is the best thing to go with. To give you a case in point, mobile phone technology, right? Because innovation is so robust, and chances are that tomorrow somebody else is going to make your technology redundant. You want to enjoy the monopoly for as long as possible and make the best of it for as long as it lasts. So there, going with patent protection may actually make sense, because if your innovation is going to be relevant for 2 to 3 years, the patent will give you the monopoly to realize your entire profits for those 2 or 3 years before some other competitor comes and knocks it out, right? And to give you an example, the Apple versus Samsung patent litigation is a great case in point. You can see just how troublesome it was for both companies to actually go through that entire litigation. And to what extent the injunction by the US court would have actually stopped Samsung from selling its products outside is a big question mark. But bottom line is that sometimes you want to be the first player in the market. You want to quickly realize your profits, and you want to go and ensure that your full potential is realized before your competitor knocks you out. So in markets or in industries where innovation is very, very robust, patents may make all the difference in the world, right? And of course, if you're a startup, raising financing, raising funding, if you have 10 patents to your credit, that automatically means that the way your investor looks at you will vastly change, right? And last but not the least, of course, you want to factor in the fact that any form of patent or registration related protection may offer limited geographical protection unless there is treaties governing it. So for example, Berne Convention when it comes to copyright, right? But not all not all forms of IP protection are enforceable across borders. Patents being a classic example. You could have an invention which is patentable in India but not elsewhere. So then how do you stop somebody from going through the patent records in India, getting the details of your invention from the application you have filed, reverse engineering that product in, say, a country in Africa, and then you have no means to stop them, right? So in those scenarios, whether patenting is the best way of protecting it or not, it's a great question to ask, and no easy answers. Any questions so far?
So on the patentability of the aspect,
Sorry?
So the last point which you were indicating, that if it is patentable in India and it is not patentable in other jurisdictions, so how to go about it? What should be the way forward?
So that's, there's no straitjacket answer for that. But for example, one way of addressing that is to say, okay, let's look at two things. Which are the markets that you want to be in? File for patent protection across all those markets. The other way of looking at it is which are the countries where infringement is most common, and try and see if you can also get a patent in those countries so that you can effectively undertake enforcement action there. But if a country does not afford that kind of patent protection, then a large part of your question will then be to sit with your client and tell them that, look, this is a scenario that we can't prevent, right? Infringement coming out of that country for export markets, right? Not Indian market, of course. Importing of infringing articles can still be stopped. But if it is, say, a country in Africa exporting the patented subject matter to another country where you don't have patent protection, then you don't have any protection available. So at that point of time, you may want to probably sit with the business and understand what is the extent of disclosure you'll make in your patent application, or should you even file for a patent application or not, and instead protect it as a trade secret or confidential information. So is there a straight answer to that question? No, it depends on every business. It depends on every invention. It depends on so many subjective factors that are impossible for us to predict. But the important thing to remember is to ask this question so that you can then determine with the relevant stakeholders as to what is the best IP protection strategy that you're going to employ. So I know that doesn't answer your question fully, but it does give you a process to fall back on. Okay. So next we come to the other question. When a trade secret and when as a patent, right? Now, the relationship between patents and trade secrets are very interesting because every patent starts off as a trade secret. So you will know that an invention that is anticipated or which is known by a variety of other means and forms. If it is prior art, already published, already in use, etc., 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 it's not patentable anymore, right? So if you have to effectively patent your idea, you have to first ensure that it is protected as a trade secret until it goes into the provisional application. And then once you have a patent application number in the form of the provisional specification, you're free to disclose it. So, but not every patent is a trade secret. In fact, on the contrary, patenting necessarily means that the trade secretability of the same idea is more or less completely compromised, right? Now, why is that the case? Because the moment I put my idea on paper, put it into a patent application, file it with the patent office, it is information in public domain, right? In that situation, you are essentially compromising the confidential character of that information altogether, right? So if you have an invention for a drug that is able to cure, say, HIV/AIDS, right, and the entire formulation is in the form of a patent application which you file it, chances are that the whole world knows now what are the ingredients that you have put into your HIV/AIDS addressing drug, right? So it essentially means that it is no longer a secret. But even though it is not a secret, thanks to the fact that you have a patent, you can actually go ahead and stop other people from exploiting it. But what happens when that is no longer the case? What happens if you file for a patent but then don't get the registration, right? Ideas in public domain, you don't have patent protection, you have yourself completely killed the prospect of IP protection. So it's very important to remember that everything that is patented usually starts off with a trade secret. But sometimes, as with the case of, say, the KFC chicken recipe or the recipe for what goes into Coke, protecting it as a trade secret might have better business benefits depending upon what industry you're in. But trade secret protection obviously comes with its own challenges, right? First is, does your confidentiality agreement effectively cover the trade secret in the definitions clause, right? And you define it in the agreement in too much detail, that itself might actually enable a public disclosure tomorrow. So you can't describe the nuts and bolts of your trade secret in the confidentiality agreement definitions clause. But you describe it too little, then the other person who's signing the agreement saying, I'll keep it confidential, she does not even know that what she's dealing with is actually confidential information and should not be disclosed. So the definitions clause in an NDA can be very tricky, which is symptomatic of a larger problem. Understanding what is trade secret or confidential information itself is a very complex exercise, right? Let me pause here and take a simple example, right? So I'm sure a lot of you must own either a precious watch or a piece of jewelry, right? So how many of you leave that lying around in a place where it is publicly accessible? And how many of you instead actually take the steps to put it into a safe place and lock it up? I would presume that a vast majority of you would actually take adequate measures to keep it in a place that is not accessible to everyone. I'm sure I'm right in my assumption. Let me now ask a slightly stranger question. So how many of you decide to tear up a piece of paper because it's completely useless and then keep that torn paper under lock and key? I would presume that none of you actually do that, where you actually destroy a piece of paper and then lock it up in a tissue paper, for example. You tear it up and you put it into a drawer and lock it up. I don't think that's going to happen, right? Unless you have some weird kind of compulsions. Now, the way in which trade secrets are understood in...
Unless I have told it by mistake.
Sorry, by mistake. Absolutely. The point of principle is very simple. We try and protect what is valuable. We don't care too much about what, according to us, is not valuable. And the approach with confidential information is no different. I'll give you an example. Information about customers. If you have reviewed a standard confidentiality agreement or non-disclosure agreement, a lot of them will say that the information about my customers, like, for example, their address, their contact details, what positions they hold, the terms and conditions of our engagement with them, the fact that we even have our engagement with them, all that is going to be kept confidential is what the agreement is probably going to stipulate. Now, the same company which says the information of my customer is confidential will probably also have a section on their website called Our Customers and list out every one of their customers. So now what do you believe? Do you believe that information about the customers is confidential? Or do you believe that it is not confidential because they publish it on the website? the court's consistent approach has been that, look, if you have yourself put it out on the website, don't expect it to be confidential, right? So the steps that a business takes to protect confidentiality is as important as the agreement itself, because you could have the most watertight confidentiality agreement, but if you don't have the corresponding measures to keep it secret, then you can't call it a trade secret anymore. You need to demonstrate that it has economic value. You need to, more importantly, have the appetite for enforcement. Because if the confidentiality information slips out once, its character as confidential information is probably irreversibly compromised. So unless you have the means to litigate at short notice and get injunctive orders, trade secret may not really amount to much, right? And it poses one more problem. If you're a business, especially looking to raise investment financing, how do you value a patent is a lot easier than how do you value a trade secret. Because with patents, you have market comparables. So you take a market-based approach, which is usually what everybody follows. And then basis that you arrive at a valuation of the patent. But if it's a trade secret, which means it is not out in public domain, and therefore you're no position to really determine market comparables, how do you compare one trade secret to the other? Because both are secretive. So then valuation becomes complicated. And if you're going to ascribe a value of, say, $100 million for your trade secret, how do you justify that to an investor? Right? I'm sure if Coke went to the first investor they ever got and said that, look, we are going to go into a multi-billion-dollar organization on the strength of this one recipe, therefore invest in us, I don't think the investors would have been very confident about the valuation that Coke came up with. Right? So these are some of the practical challenges that come with trade secret versus patents. Right? And as opposed to patents, where even if you don't enforce it once or twice, you don't really lose much. In trade secrets, you don't end up enforcing it once and it leaks into public domain. You have essentially lost the entire value proposition around that intangible asset. Right? So choosing a patent versus trade secret is an extremely nuanced conversation. It's a lot of dialogue with the business teams, the technical teams, trying to understand what are the market dynamics governing it. And then you as a lawyer will have to take a final call on what is the option that you recommend. Right? And make sure that you inform the pros and cons of all of this. And then if the clientele is okay with that, then you kind of propose the steps accordingly. Right? But bear in mind that these kind of trade secret protection programs can just as easily aid the cause of patenting, because it prevents the leakage of ideas, as it would be to protect the trade secret component as well. So having this robust program is anyway a good idea. But whether you only go with this or you go with the patent as well depends on a variety of factors, right? If you have a drug which could, for example, have life-changing consequences and it's novel, there's no reason to keep it as a trade secret. You might as well patent it. And the question that I always ask my clients is how easily or how effectively will it be a case where a competitor can kind of get into the same product without spending too much time, effort, and money into it. If the answer is that they will probably eventually figure it out, then maybe patenting is the best option, because that way at least you control the narrative. But if you decide to protect it as a trade secret in that scenario and somebody else generates it on their own, then you're left without a remedy or a relief. So choosing this, again, as I said, a variety of factors. And bear in mind, Coke managed to transcend geographical boundaries. Today, they can function in multiple boundaries. They probably didn't spend too much money on patent protection, maybe a lot of trademark registrations, but they've been effectively able to cement their position as market leaders without too much effort. Same could be said about KFC as well. So each has its advantages, and the advantages or the disadvantages is very sector specific, very industry specific, very business specific. But these are the broad parameters based on which you actually take that decision. Right? And based on that, the legal steps will follow. Right? You have a trade secret policy. The trade secret policy, does it involve a good watertight confidentiality agreement? Do you have technical measures in place to be able to quickly ascertain the source of leaks? Right? So you could have a situation, for example, where biometric passwords are installed into computers. So if a mail containing confidential information is going out of the network, you are able to pinpoint it to a particular user. So these are some things that has to be put in place if things have to be protected as trade secrets. Patenting, of course, because there's a registration from the government itself, it's a free license to enforce. So, but again, the bottom line is it's a nuanced question. It's something that you have to very carefully determine on the facts of each requirement and then take an informed decision as to which way to go. Last but not the least, again, lawyers can't be bystanders. You need to understand the field of technology. You understand the field of business. You will need to understand the requirement, and you have to be able to think laterally across different considerations to be able to actually effectively protect IP and manage innovation in the business. So practices and policies have to change based on changing legal landscape. Moonlighting becomes a trend. How effectively have we been able to be ahead of it? So that, I think, will determine the successful lawyers of the future, being ahead of the curve. And last but not the least, IP protection cannot be reactive. It can't be specific to each individual requirement. There has to be a preconceived strategy. It has to be holistic. It has to be rational. It has to be customized. And what follows should be a proactive approach to innovation management as opposed to reacting to developments constantly, right? So you want to put in place measures that can survive your own existence in the company. So even if you're not there tomorrow, the IP strategy that you define should be able to take care of itself. And I think that's the only way to proceed. I think that brings me to the end of the session. It's exactly 8 o'clock, so I've thankfully not overspoken. Thank you, everyone, for your patient hearing. And any questions, please let us know.
Yeah, thank you. Will we be getting access to this presentation or?
Yeah, sure. We will be uploading the recording, so the recording will be available on our portal.
Yeah. So thank you very much, Ashok. Just to summarize on the discussion that we have had today, all that we have understood, and we have sort of very much the practical perspective of how difficult actually it is to even identify the right kind of intellectual property rights. That itself is a challenge. So that's where, like Ashok was just mentioning, it's not just something that you can just identify something, and randomly provide some kind of consultation on subjects like these. This needs to be a proper IP protection strategy that we need to develop. And in order to develop a good strategy of this sort, a thorough understanding of intellectual property would be required, a thorough understanding of management would be required. And there were some very interesting and intriguing questions as well as illustrations that were brought about by Ashok, which I'm sure the participants would go back to ponder over a little and come back in the next session. What we would also request the participants is, there are reading material that is already available on the portal that Dr. Anshul has provided. So you could probably go back to some of the readings, including some of what Mr. Ashok also mentioned today of the Google versus Uber cases and various others, where you get a complete insight into what we have discussed in today's session. You can also go over the presentation at your leisure once again, where some of these important points, some of the illustrations were brought about, and hopefully you will come back more prepared for the session. So you have a whole day tomorrow to just sort of go through what we have discussed in today's session. Go back to the questions that Mr. Ashok had raised during the discussion. Probably you would not have insight into it immediately, but you would want to go back to these questions and consider them in more detail. So we would like you to come back on the 22nd of March at 6:30, where Ashok would also be taking us through the actual commercialization of the patents through the various forms. You will also have some hands-on experience in terms of what are those interpretations, some of the interpretations that Ashok did also mention today of the NDAs. What if you are transitioning from one form of confidential information to the other, and if you missed out on a novation clause, which is very, very critical. So we will have more insights into the actual commercialization of patents, some of the contract draftings, and what are critical aspects of contract drafting in case of intellectual properties, especially patents. So this is going to be our subject for the next session, that is on the 22nd of March. And we look forward to meet you then with probably more insights into the subject. Thank you all and have a nice evening.